I think we can start. So, hello everyone, and welcome to this panel at the American Society of International Law. My name is Marko Milanovic. I'm a lecturer at the University of Nottingham and the Secretary General of the European Society of International Law. And it is my great pleasure to welcome you here both on behalf of ESIL and on behalf of ASIL. And this is one of several events over the past few years that ESIL and ASIL have done together that include, for example, a joint symposium of ESIL, ASIL, and the two journals, the European and the American Journal, various other events. And this is yet one more way in which we from the European Society want to sort of showcase our society here at the ASIL annual meeting. And present in this room and throughout this conference are many people from ESIL as well, including our past and current presidents, our past president, Anne Peters, who is to be thanked for organizing this particular panel, and Laurence Besson de Cherzoun, our current president. And we would all encourage you to join our society. Don't be so happy. Our next event is the Research Forum in Amsterdam, which is going to take place next month. And its topic is international law as a profession. And our next big conference will be in Vienna in September next year. So we would strongly encourage you to join. And if you have any questions with regard to the European Society, please ask any of us present. And it is our great pleasure to have Professor Alain PELLET here with us, one of today's really great international legal scholars at this interview. I have to follow official instructions and remind you before we start that all attorneys seeking CLE credit need to scan themselves like cattle when they enter and leave. So, with me at this panel are Antonios Tsanakopoulos from the University of Oxford and Freya Beitans from the University of Leiden. And we hope you will have a nice and enjoyable hour with us and with Alain PELLET. And we will run for about an hour, and then we will have some half an hour or so for questions from the audience. And I turn over now to Freya, who will introduce our interviewee.
Okay, thank you very much, Marco. Of course, Professor PELLET, Alain PELLET, is somebody who does not really need an introduction, so I'll just highlight some aspects of his very impressive curriculum. He teaches international law at the University of Paris-Nanterre, where he was also the director of the Centre de Droit International. We all know him because he's written numerous books and articles, and he's also the president of the French Society of International Law. And as he just told me, that's something new. He's also the independent objector of ICANN, which is the Corporation for Internet Domain Names. Apart from his academic work, of course, Professor PELLET is very well known as a member and a former president of the United Nations International Law Commission. He has advised many governments, including, of course, his own France, and he acted as agent or counsel in more than 40 cases before the International Court of Justice and many other tribunals, including arbitral tribunals. So I shall start with the first question, of course, in which we link the topic of this conference, so international law in a multipolar world, to this particular panel by asking Professor PELLET, one possible interpretation is of multipolarity that there are now more states and international organizations which make a significant impact on international lawmaking. On the other hand, there are lots of people who say, no, that's not true. It's still a unipolar world, and we would like to hear what you think about multipolarity or unipolarity.
Thank you very much. Well, first, although I am very grateful to the American and European societies to have taken this initiative, I must say I'm quite impressed, because it's a very long time since I have not sat for exams. And, but well, this looks more like a sitting room than a classroom, so it's okay. Thank you. So let's go straight to the question, because I hope that we keep half an hour for the exchange with the audience. Well, I would think that the word First, I don't think that the world has at any time been unipolar. Maybe it was more or less unbalanced. But I think that this idea that even the American empire has been totally under the domination of the US only is just not true. I think the US has never been in a position to decide alone. It had to take into account the opposition both from inside, including Asterix, France Asterix, and from outside, of course, the Eastern Bloc and China. So I don't think something like unipolar world has ever existed, and of course it's even more true in the past. This said, I'm not a political scientist, where I think that the question, your first question, relates more to international relations and to law, strictly speaking. But I think that the international law making was always a result of check and balance. It's just now the checks and the balances have changed, and but it is not dual polar, and it is not and it is multipolar in a very limited sense, I think.
But what if we extend this a little bit? So what if we understand multipolarity to mean not just that states are involved in lawmaking today, but also, for example, international courts, international organizations, but also other actors like even domestic courts. I mean, international law sees the state as, you know, unitary, but in reality there are many different actors within the state that may affect lawmaking, and perhaps multipolarity can be interpreted in that way.
Well, this for me is more striking than the passage from a pure unilaterality to a multipolarity. This, I think, is much more striking and probably is a real change in the international lawmaking and law of the modern state. This said, I'm not sure at all that the Westphalian model is dead. I think that contrary to some political scientist or political scientist approach, the sovereign states are still there, and quite interestingly, I think the non-state actors quite often, and more often than not, do situate themselves in relations with the state. I am a strong supporter of something which is both English and French origin, the Lex Mercatoria. The Lex Mercatoria clearly is a way for economic private powers to try to bypass sovereignty, but the sovereignty is still there. So I think if we, this transformation of international law, which is very striking, must still be thought in view of this state sovereignty. The other aspect is the rise of a new system parallel with the system of sovereign juxtaposition of sovereign states, and with the rise of the idea of international community, and not only community of states, even though in the Vienna Convention, in Article 53, you have the community of states as a whole. I think now we really have an international community. And this, for me, is also extremely new. It is slow, but I think that the dialectic between sovereignty and community has become, really must become part of the international thinking.
So we've now done a nice homage to the theme of the conference. So we can move to slightly more sexy topics. So let's talk a bit about some things where you really invested a lot of your time and energy in. Specifically, we wanted to talk to you about the International Law Commission and your work with the ILC. as well as
what Marco understands as sexy.
well, we are all nerds, are we not? Let us not be ashamed. So, so let's talk a bit about the ILC, about the Badinter Commission, and then we will move on to various aspects of international adjudication, which you were involved with. So now you will all be aware, of course, that the ILC has recently completed this enormous work on the law, on reservations to treaties, producing this mammoth-sized guide to practice. And this is an endeavor that took 18 years or so, during which you, Alain, were the ILC's special rapporteur. And the big issue in that work was the question of invalidity of reservations, and what are the consequences of invalidity. And you will all recall the big fight about reservations to human rights treaties, the diverging views of human rights treaty bodies and some very powerful states. And I think it is fair to say that when you started your work as the ILC Special Rapporteur, you were you leaned more towards what, say, France, the US, and the UK were saying than to the droit de l'hommiste human rightist approach. But as years have gone by, I think it's fair to say that your position has evolved and that the Commission has now adopted a compromise on that. So can you tell us about how this evolution came about and what do you think will come out of it?
Well, it's perfectly true that my position evolved. I think that les imbéciles qui ne changent pas d'avis. So it's true that my first approach was very unitary. I wanted to have a guide to practice and reservations to treaties and not have a guide to practice and reservation to an environmental treaty, human rights treaty, etc. This is true. This said, on this I have not changed my view, and if you look at the, I think, 190-something guidelines of the Guide to Practice, you will not find the expression human rights. It does not appear, and it does not appear because I think that the law of reservations to treaty is just applicable, and the Vienna law, Vienna Convention law, if you want, is just applicable to human rights treaties as well as to any kind of treaty.
So it is this resisting fragmentation. That is how you saw yourself in the work of the ILC.
Yes, I mean, I have nothing against some kind of fragmentation. I think law must be adapted to specific needs. But I think here you don't need that. I have always been said by human rightists, oh, but, you know, my law is not reciprocal. Okay, if it is not reciprocal, you don't apply reciprocities. That's the end of the question for me. So it doesn't matter. You can perfectly apply my or the ILC guidelines to human rights treaties as well. Now, you said I changed my view, and this is true for the specific issue you raise. That is the fact, what is the effect of an invalid reservation for the reserving state? This I have changed my view. And I have changed my view after a long, difficult dialogue with the human rights bodies. When I made my, I think, third report, I said, well, go to hell with General Command number 24, even if it was written by very capable international lawyers, including Dame Rosalind Higgins. I don't think that you need to have this special regime. And I still think that we don't need it. But I have been influenced by their position. That is, that after all, their position can meet the needs of the general international law. So we had a very difficult dialogue. We met several times, the ILC met several times, all, I think, the human rights bodies, separately or together. And at the end of the day, I was convinced of some, not all, but some of the, what I call human rightist approach, that is, that something has to happen, and there is no reason that you must take an absolute extreme view. What is important for me, and in that I am still US, UK, French oriented, if you like, what is important for me is that the will of the state must prevail. The states know whether they want to be bound or not, and whether they want to be bound with or without their reservation.
But coupled with that very nice little presumption you put in that if they stay silent, which most of them do, they will be considered to remain parties to the treaty without benefit of the reservation.
Yes, but with a very good, important concession to the state. At any time they can say, I want, I don't want. Which I think, whether or not the human rights like it, is the BAB of the law of treaties. The law of treaties is based on the will of states.
So you have created a compromise
state
now?
to be bound without his will. Nevertheless, if the state says nothing, you have to make a decision. Whether the presumption is positive, the state is bound by the treaty without his reservation, or is not bound by the treaty because it is invalid, the reservation is invalid, and it cannot be bound because it is contrary to the object and purpose of the treaty, for me is rather neutral. It doesn't really matter. I was rather in favor of the human rights bodies because I think there is a practice, and why oppose that?
But so you crafted a compromise, right? You created something that you concede something to the human rights people by saying, okay, reservations can be severable if they're invalid, they're now. On the other hand, you give something to states by saying you remain the ultimate masters. So the big question now, right, is whether that compromise is to be accepted, that you so carefully crafted, is to be accepted by those who you built it for. No. And there's this, so Harold Coe in this blog post on Opinion Juris recently labeled the compromise that you put, he described it as saying that it makes little sense and smacks of unfairness. So that's not very optimistic, no.
Well, Harold Coe used to be an excellent lawyer before he became the legal advisor of the Department of State, and I'm sure he will be so again now that he has come to the problem with legal advisors is that they don't speak for themselves, but they support a state policy. And there's nothing more heavy to change than a state policy, especially I would think for these rather small technical problems. And unfortunately, they do not bother, I mean the legal advisors, they do not bother to pay much attention to the opposite argument and keep repeating the same rather closed-minded refrains. This is why I must say that the debates in the Sixth Committee for me are so depressing and uninteresting. You know, it's a parrot's cage. It's where representatives of states either repeat what they have always said themselves, or repeat what the other states, when they are less prepared, if the first category is prepared, what others have already said. There can be exceptions, I must say, and I wish to mention one. I don't know if he's here, but the only exceptions I have ever noted in the Sixth Committee, where I have been many times during my 22 years in the ILC, is Sir Daniel Betlems. He is the only legal advisor who once say, well, we might be wrong, we will try, we will think it again, and maybe next year we come with a new position. all the others, I would say, blah, blah, blah. We have said that, blah, blah, blah. We said this again. This for me is not acceptable. And I say, I think that the Sixth Committee is a terrible place for to be.
Tell us what you really think.
Well, now I have no reason to be more. Well, I will be next year because I have to sell for the last time my guide to practice. But this said, and to me, to give a short answer to your question, I think that the ILC compromise is reasonable. I think it is rather clever. It might be debatable. The presumption might be debatable. Once again, I don't care, provided there is one presumption. I think it is more reasonable not to antagonize the human rights bodies who have been very consistent in their approach. So I think it is reasonable. Let's hope that that only fools never change, and that even the states, the states who are so tough on their consent principle, will understand that we are just offering a reasonable consent principle approach.
Moving from the ILC's guidelines to the ILC more broadly speaking, in an article forthcoming in an EJIL symposium, which you should all read, of course, on the ILC's work on reservations, you noted that only a handful of your colleagues in the ILC were actually helpful in your work on the guide, with the great majority being indifferent and not being highly qualified international lawyers in the first place. You also noted that a certain member of the ILC, if you want to know more, you can read the article, was a pure nuisance whose intolerable and anti-scientific attitude threatened the completion of the study. That is quite outspoken. So what are your impressions on the composition of the ILC and the selection of its members?
Well, I will not comment anymore on the actual member. It is a Chinese member. But I must say that while the previous Chinese members were, I had very tough debates with Madame Xue, for example, but it was possible to have exchanges with her, with President Xi, with Mr. He. With this one, it's simply impossible. This said, concerning more generally the composition of the ILC, I don't generalize that much. It's not exactly what I said. I said that for this topic, it's true that many of my colleagues were not interested. They were not interested because it was too technical, probably too long. Maybe the special rapporteur was not was simply bad. But so I don't say that the great majority of the members were or are not highly qualified international lawyers. Certainly, all are not. Some are really desperate. But the ILC now is not the ILC of the 1970s, where really you had there the best and the brightest in international law. Now it's not true. I think that you have good lawyers, average lawyers, very bad lawyers. You have everything. Anyway, it's too big. I have really doubts that, globally speaking, the most highly qualified publicists in different nations are there. You have too many diplomats, and the result, which is not sane, I think, is that the job is done mainly by a handful of Western professors, and this, I think, is not very satisfactory. Now, is it remediable? Well, I am not sure. Not because remedies are unthinkable of, but because I think really the problem of the ILC is that states do not care. States do not care. The ILC exists, so they keep it, but they have no plan for the ILC. They do not care. And as long as they will not care, it's rather, I don't see any real remedy. Personally, I would be rather in favor of suppressing the ILC
that experience and what the Badinter Commission did, especially in light of the separatist movements that seem to be firing up again, even the United Kingdom, but also in Belgium and Spain and other places. And is this a question, the question of secession and so on and so forth, that can be answered by international law? Or is international law merely exercising a sort of justifying faction ex post facto?
Well, two caveats. First, I was not an expert. Unfortunately, I was the expert. There was no, so I am responsible for all the drafting, except opinion number 3. On the boundary, which was written by, I can tell you now, the Spanish member of the commission. All the others, I am responsible, but I am not responsible for the whole content. I had 5 divas against me, who were the president of the Constitutional Court, and for example, I explained to them what was what meant jus cogens, something none of them has ever heard. And they were so enthusiastic that they wanted to put jus cogens on every rule of international law, including, for example, the rights of minority. And for me, it was not jus cogens, but well, what could I say? They said the parental norms now protecting minorities. So I had to write this against my will, I must say. The second caveat is, I think really, there is nothing in common between the ILC and the Badinter Commission. Maybe you have a very French formation. You need to have 2 subsections.
It was the plan binaire. Yes, we had to do it.
Okay, well, then you are a good pupil. I would think that so it's if. It means something. If you want a comparison, the best comparison probably is really with jurisprudence. It's part of the jurisprudence, a word advisory opinion, but by non-international lawyers, except if you accept that I was the author. But once again, I was the hand more than I could not impose all of my views, at least. So these are the caveats. Was it useful? I think it was. I think that it helped to have a legal view, a legal framework for the Yugoslav crisis. You cannot ask lawyers to solve all these very, very difficult issues. But I think it did. It reinforced, for example, the weight of the iudi possidetis principle. Now I think that it would be very difficult to say that it is not applicable outside, beyond the decolonization process. So I think for things like that, it is, I think important. Is it dangerous? I don't think that we, if I may say we, have encouraged secession. We have just said, well, look, you have no right to secession. But if a secession occurs, better to draw consequences from that. And in this respect, I think we were only pragmatic. We have said, well, and if you remember well, advisory opinion number 1 was reluctant. I was reluctant. My clients were reluctant. We did not want to encourage secession. But, well, so we say, well, it is in the process of secession. And we wanted to know whether it would stabilize or not. It did. And very quickly, no reasonable person should have said, no, Yugoslavia is still possible. When something is impossible, I think law has just to say, okay. So what we did is just to accept that law is cannot do everything, but must draw the consequences of what is unavoidable. This is my explanation for, says the jurisprudence of the Badinter Commission.
Shall we move on to the topic of international adjudication?
Sure.
Yeah? Start.
No. If you say adjudication, I will come. So the court, you appeared several times before the court, the International Court of Justice, more than 40 times, if our calculations were correct. Your first case was Nicaragua, And there you appeared together.
One of my first cases.
Burkina Faso, Mali.
Burkina Faso.
Okay, but in Nicaragua you appeared together with Ian Brownlee. Some people have suggested that there should be something like an international bar to which all councils are members, just to make sure that there is the same standard that you and Ian Brownlee set out back then, and to avoid that some councils bring arguments that are not legally convincing or not even legally tenable. What do you think of that idea?
Not good. I think you don't need that. Honestly, it's true I have been probably in 40 and something cases before the ICJ, and the same is true for ITLOS or interstate arbitration. Honestly, I think that globally it works well. States want to appoint bad counsel. It is their responsibility. The judges will have to endure even worse pleadings than they endure from us. I know that some judges say, well, it is a small bar, they are always having the same kind of jokes or things like that. I think, honestly, that globally it is acceptable.
But it is a club, no? I mean, so one question that we can ask you is how you got your foot through the door in the first place. So how did you get those two cases?
My boss is here. He is a permanent agent for Nicaragua. I think he has got 8 cases as the agent. This record will never be defeated. Well, my record, 40 cases or 45 as cancelled, can be, but his cannot be. So this gentleman, who is Carlos Arguello Gomez, now is the permanent agent before the International Court of Justice, visited me in Paris in 1993 or 4, and no, he did not visit me. He first visited the Minister of Foreign Affairs and the legal advisor, who at the time was Gilbert Guillaume. And then he visited the head of staff of the Prime Minister, who was a socialist at the time. Probably he wanted to have some guarantees that he could find a council which was technically acceptable and politically not too unacceptable. And it happens that he had 2 lists, and I think that the only name on both lists was me. I suspect that also he found that I was less expensive than the others. So this was probably the reason.
But do you think so? So Nicaragua is often credited, the big case, the military and paramilitary activities case, is often credited with reinvigorating the court after the whole Southwest Africa fiasco. And do you think that's the case, or do you think Nicaragua is overrated?
No, I think it is the case. I think really it showed that a small country could, it was really Goliath versus David, or David versus Goliath maybe, and I think it was seen as something encouraging, that the court could be a place where, contrary to the Security Council, the balance of power it could not work. I really think it was, and I've seen that in my posterior practice, people saying, oh, but then Nicaragua shows that law can... I have no judgment on whether the court was right or not, but certainly it was...
Certainly on jurisdiction, right? On jurisdiction, you would probably be more ambivalent.
I have always said I had mixed feeling on that. But I think really, still now, states, when they visit me, say, isn't it biased? Isn't it too much Western, too much? And I say, well, look, my first case was Nicaragua, blah, blah, blah. And they say, oh, yes, that's true. Then it was, so I think really it reinforced. I must say also, because this is, Nicaragua is always seen as an important incentive for small states to go to court, but I'm pretty sure that Burkina Mali was also a good bargain for the court, because 1986 judgment by the, which was mainly, I suppose, drafted by Bejawi, the chamber judgments, is a splendid one in many respects, and certainly for the French, it's a kind of wonderful French draft, and but also I think on the substance.
But also because it was a purely African case between two Africans. Well, with the French sort of putting everybody.
Well, if you want to know everything, I drafted the special agreement between the two, and then it was imposed to both by France. So it's true, but then it worked. It worked. Both countries were absolutely enthusiastic of the case, and I think it has brought African countries back to the courts. So I think both Nicaragua plus Burkina were really a couple of reassuring judgment for third world countries. Well, what is a problem is that probably it kept out the US and the Western countries. But
well, you say that countries bring.
And the bottom line to this is, if you want to get a nice, what we need to do is start a fight and dump services in the market. Apparently, just make it really cheap so people take it.
Well, you say countries bring claims before the ICJ. Well, actually, recently this year, last year, they didn't. They have many other options these days. They can bring them before the International Tribunal for the Law of the Sea. They can bring them before the Permanent Court of Arbitration, etc. So, do you think that these options, that the ICJ is competitive on the adjudication market, so to speak? And what would you do if a client comes to you with, let's say, a boundary dispute? Where would you go?
I would go before the ICJ. My view is that the ICJ does a job. It does it maybe a little bit too slowly, but I think states are responsible as much as the What I cannot understand is how they can need 7 or 9 months to give a judgment on a rather small case. I think I pleaded Burkina versus Niger in October, and I will have the judgment on 16th of April. This is too long. But beside this, I think the ICJ is rather efficient. I see no recent judgment which is really criticizable by honest, neutral mind. So, and it is much cheaper than having an arbitration. So, and they have a good know-how. Honestly, I think the registry works well. So personally, I would rather keep it as it is, and I think that it should be competitive. I have no explanation for the recent apparently disinterest for the World Court. But if you take the purely interstate cases, yes, there's been no case in 2012. For this moment, no in 2013. I rather know well the market, even the cases which we expect are not sure to come. But there's not been that many interstate cases outside the ILC, the ICJ, sorry, the ICJ. You look, there is Croatia, Slovenia, but clearly you have also an ex equod bono clause, which explains probably, I would not go before the ICJ for an ex equod bono case. I prefer them to stick to law, strict law. So, and beside this, there has been the two Gulf of Bengal case, but in the recent, as far as I know, so it's not. It's a blip. It doesn't affect, especially the ICJ, I think.
So the ICJ is cheaper and still an attractive forum, but don't you think that some reforms are necessary? Because, I mean, why go to arbitration? Because you can have a sitting that lasts 8 hours a day, 8 hours or 10 hours a day, and you can do it in jeans, and you can actually ask questions. Whereas in the ICJ, it's an hour and a half, la cour, and then you cannot ask any questions, or if you ask questions, you have to give 2 weeks to the states to think about it and then answer in writing. So what's the point of that? So a number of judges and counsel have expressed a dislike for the current sort of 1920s process before the court. Do you think we need some reforms in that respect? Or?
Well, certainly I would recruit you to say la cour. You said very well. beside...
Do I get to wear the
Yes,
gold?
The golden chain, yes.
No, my answer on that, and honestly, even if it looks like a joke, is that I think that the solemnity, the formality of the court is something which states do favor. The justice must not only be done, but be looked to be done, and they have this impression that this is public. The public can see what has been pleaded. Recently, I've seen that in Peru, Chile. There was a lot of press. The press quite often goes away because after the one day, so it's so boring that they leave. But in that, and I pity the judges for that, but they stayed. And quite often, more often than not, the cases before the ICJ are really sovereignty cases or war and peace. And I think these solemn, formal things, if we appeared in jeans, I don't care, we could come in jeans, I have no problem with that. But I think they would think, no, this case deserves more. I think the ICJ offers this kind of service. Maybe if there were very small cases which were not sovereignty cases, which it would be too much. Maybe the, how do you say before it lost the prompt malvé in English, I don't know. The cases for the...
prompt release.
Yeah, prompt release cases, which are, maybe this is too solemn, because the ITLOS is as solemn as the ICJ, or even more. But because this could be rather quick exchanges. So this is for the formality. For the questions, here again I have mixed feeling. Look at my preferred agent here. If I am asked questions and I answer my own way, that is very spontaneous, and say something, say, oh no, after all I changed my mind, and I say things which in fact are mixed problem for Nicaragua. Why, I think you can take 2 days and answer. So, no, I am rather, maybe because I'm part of the ICJ mafia, I am rather in favor of keeping that grosso modo as it sounds. So, this being said, having some more questions, no, I would prefer something else. I would prefer that the court, in advance, tells the parties, we are not interested in that, we are interested in that. Of course, you are free. You are sovereign states. If you want to plead what is not interesting for us, do it. But we warn you that we would like that you deal with this or that. This I would perfectly admit and I would encourage. But this just having questions because before a common law tribunals, it is the habit, I am not in favor.
But the question is more, I think, you're right that there is a common law, civil law divide when it comes to oral advocacy. But I think that the question raises a more profound question, which is what is the point of it, right? Why have the oral hearings as they are now, when they essentially consist of you standing at the lectern and reading out very beautifully what the president is following as a text which he already has? It is essentially a third round of written pleadings. Mm-hmm. So the question is, why do we have oral hearings then in the first place? I mean, other than for you to earn a lot of money.
Well, I have as much money for written pleadings.
Well, exactly.
So it's not the issue.
No, because the English at least version of oral advocacy, which, for example, the Supreme Court in the United Kingdom does in excruciating detail. So it goes on for days and days and days in very important cases. It's not like here, for example, where the Supreme Court is half an hour and you're done. It's to help the judges, especially when it comes to extremely complicated legal questions, where an answer on the spot would actually be useful. And I think that's the more, that's the way in which oral hearings could be more productive.
Well, I would think that I have already answered this question, even if you make it more aggressive. My answer is really twofold. First, justice must look to be done, and for public opinions is the only time where it is looked to be done. It is, I think in all my recent cases, the pleadings were integrally put on the TV, main TV channel. So this is part of the answer. And the second part is definitely that before civil law court or common law court, you don't have sovereign states appearing. And I think that even though, of course, if they retain you, it is because they are confident in you. Nevertheless, I think it is legitimate that the agent and the political... I think for Peru, I had in my team 5 former ministers of foreign affairs. And they don't want that I be uncontrollable. They want to be sure that what I say is really something which would not have problems for. So honestly, I think it's not because it pleases common law advocates that it is good. It is these are special cases.
Judge Tomko did ask a question recently. I think it was in Belgium, Senegal. People almost had a heart attack. I forget. It wasn't like, would it now be a good time for a break? He actually asked a substantive question, didn't he? So maybe, I don't know.
Well, once again, the answer is no.
No.
I just have one final question on the ICJ before moving to other fields of question. One thing that always struck me as a bit odd is the system of ad hoc judges, because you have the idea of independence and impartiality of the judges, and then countries do insist that there's at least one of their nationality there, as if that person would understand them better or be more inclined to judge in their favor. So what do you think about ad hoc judges, or the system in particular, and about the selection of judges more broadly?
Well, very quickly, ad hoc judges, I think this also is reassuring for the states. They think that if they can appoint a judge, it means that it doesn't... Well, I know now quite a lot of ad hoc judges ad hoc who have voted against my state or against their state. So, and this is all okay. But I think having a judge which you have appointed gives a guarantee that at least all your argument will be discussed. This is a way states see that, and why not? The other possibility would be that if you have a judge, a national judge in the court, he would have to step out. But I think there could not be a Japanese judge and no judge from Australia. In the Welling case, no, it's not the next one, but I think it's, so I am rather in favor of the judge ad hoc. I think it doesn't harm. At best, they neutralize each other. Once again, I think honest and good judges ad hoc can only vote for what is reasonable for their appointing party. So this is the first. As for, I will disappoint you also on the election process. I think it is a little bit like the, how would you say that in English, Aesop tongue. It's the best and the worst thing. Or like democracy, it's a worst system, but before all the others. I think the main thing is that really states play the rules of the game, so that they accept to have real PCA groups, that they accept to let the PCA decide in all conscience. What I really would love to see is the end of the vote trading. This, I think, is a shame, but it's a fact of life, and I don't see...
But do you think it would be a good idea to have perhaps a slightly longer term for judges, but without the possibility of re-election?
Okay, 12 years without re-elections, why not? I have no strong views also on that. I think maybe 9 years or 7 years with one mandate is as good. I think these are rather secondary things. Once again, I think it works rather well.
Okay. Well, so leaving the ICJ, but staying into adjudication for one final question, and this has to do with the fact that a significant amount of international adjudication, if I'm permitted the word, actually takes place today in domestic courts of various states. So there are many international law arguments that are raised before domestic courts. Many of your colleagues who regularly represent states in the ICJ are also active in domestic court litigation, in international law issues. And first of all, we wanted to ask what you think of this development. Is this a good thing that there is apparently increasing sort of engagement of domestic courts with international law? And the other thing is
So it's just because you asked a question, but you are not really.
well,
so look at it again.
I guess the answer to that would be we in the United Kingdom we had 550 cases in the last year. And
we probably had 550 cases. I speak of the leading cases with new things. So no, we are not updated.
Okay, so let's quickly move on. The last topic before handing the floor over to questions, the last topic we would like to address is differences between European and American approaches to scholarship. And some people still harbor these rather romanticized ideas or feelings about a truly international legal scholarship transcending nationalist feelings as in the days of Grotius, Calvo, Martens and so forth. So would you say that international scholarship has always been more regional, or is this something that is a bit more recent?
Well, first, I don't think that international scholarship is regional. I think there is an interesting move, a trend to have regional organization, and inside of these organizations you have this enormous body of regional law inside international law. But I think international globally I think there has been a big bang of international law rules probably during the 90s. And these international rules are international, they are not regional. This is part of the answer. Second part, if there is a national approach of international, it is really in this country. I have always been totally amazed to see that for the Americans, international is first of all a constitutional problem. For me, it's incredible not to have an international approach to international law. And sorry to say that in this audience, but I think it's rather shocking. International law is international. It's not national, it's not constitutional. And I have been, a long time ago, I was involved in an evaluation panel organized by the American Society, which was called ASIL, and I was totally amazed to see how international law was taught. It was taught constitutionally and fragmentally. International jurisprudence or things like that did exist in virtually maybe 3 or 4 universities. Now, to go one word on your international legal scholarship and 2 very short answer. First, I think that save for recognizing the Western origin of international law as we practice it, it is not regional. Second, I think that in fact international scholarship does exist today. And I think the 3 of you are extremely representative of that. I have Googled you, of course, because I was so afraid that I wanted to be able to say, hey, but you're here. I must say that it's very interesting. The three of you, you are from three different countries. You have taken your degrees in your countries, and you have come to another country. Then you have come back, the three of you, to Britain. I think you should have come to France, but it happens that it was Britain. But nevertheless, I think you are just part of the truly international scholarship, and that's very comforting for the future.
Well, with that warm, fuzzy feeling, which is now developed on our hearts, can we conclude this interview with perhaps a final question? Turning back to the topic of the conference, multipolarity, you say that scholarship is genuinely international, but isn't it true that we have all, for example, we are all speaking the same language, English, to a huge extent? Experiments at, for example, multilingual journals like the European Journal, which started off doing both English and French, have, for practical reasons, for no ideological reasons, for practical reasons, led to the EJO continuing to be published only in English. Do you see there's a value lost? There's a value gained in having a common language that we speak, but is there a value lost in losing this multilingual and multicultural, to an extent, perspective?
Probably here again I will disappoint you. I am a treater. I am a treater in that personally I think that it is good to have one common language. English speaking persons are extremely generous. Even my PELLET English is accepted by everybody, provided they understand, they follow. We have the same language, but we have not the same way of thinking. And the way I certainly look very French to the audience. I am French. I speak this. I can communicate with you. I think it is much more important than to have. Now, I will put nuance to that. As a member of the ILC, I have really seen the merits of having two working languages, because it forces the members of the ILC, and I suppose it's the same for the ICJ, to check that what they're writing in one language is really accurate, international is international, and it is very important to be understood by people with different way of thinking. And I think this the existence of a checking language in this kind of body is extremely useful. So I would not favor, whether it is French or Spanish or Chinese or Hebrew, I suppose would not
to open the floor to questions from the audience. We have about half an hour-ish. I would encourage you to ask questions there at the microphone and to be brief.
And please to introduce yourself when you ask a
Sure.
question.
Please.
Yes.
Matthias, okay. Does it work? Can you hear me?
Yes.
Yes.
Okay, excellent. My name is Matthias Goldman from the Max Planck Institute for International Law in Heidelberg. Professor Pellet, I've got a question
Hello, my name is Roland Legault, ou Roland Legault, si vous voulez. In the spirit of our common language discussion, I'll ask my question in English. I'm with at least partly tongue-in-cheek. But I am curious if the reasons why a legal advisor has to stick to a particular line over and over and over again are very clear. They're very obvious. They don't need to be explained. But in your case, where you move from being counsel in a case and then going back to academia without ever really leaving academia, do you ever feel constrained in your academic writings by positions you've taken on behalf of the state in the course of an ICJ case?
Honestly, never consciously. It is true that when you really work on a case and you dig up your position, probably you, at the end of the day, you end in being convinced about what you have pleaded. Sometimes, not always. I'm afraid to say before some of my judges that sometimes I plead things which I think totally stupid. But well, you have to do the job and to try to convince judges. Maybe some judges will be convinced by stupid arguments where I am paid to get voices. But honestly, I have never consciously changed anything, and I am rather, and I tell my students also, be careful. What I write as a scholar, as an academic, is